Let me be clear about several things about the whistleblower. First of all, I don't know who the whistleblower is. I haven't met them or communicated with them in any way. The committee staff did not write the complaint or coach the whistleblower what to put in the complaint. The committee staff did not see the complaint before it was submitted to the Inspector General. The committee, including its staff, did not receive the complaint until the night before Acting Director of National Intelligence. We had an open hearing with the Acting Director on September 26, more than 3 weeks after the legal deadline by which the committee should have received the complaint. In short, the conspiracy theory, which I think was outlined earlier, that the whistleblower colluded with the Intel Committee staff to hatch an impeachment inquiry, is a complete and total fiction. This was, I think, confirmed by the remarkable accuracy of the whistleblower complaint, which has been corroborated by the evidence we subsequently gathered in all material respects. So I'm not going to go into anything that could reveal or lead to the revelation of the identity of the whistleblower, but I can tell you, because my staff's names have been brought into this proceeding, that my staff acted at all times with the most complete professionalism. I am very protective of my staff, as I know you are. And I'm grateful that we have such bright, hardworking people working around the clock to protect this country and who have served our committee so well. And it really grieves me to see them smeared, and some of them mentioned here today have concerns about their safety, and there are online threats to members of my staff as a result of some of the smears that have been launched against them. I can tell you there's no one who can understand the plight of Ambassador Yovanovitch more than some of my staff who have been treated to the same kind of smears and now have concerns over their own safety. They acted at all times with the utmost propriety and integrity. Your Senate Intelligence Committee and your chairman and vice chairman can tell you, encourage whistleblowers to come to their committee, and so do we. And when they do, we try to figure out, is their complaint within the scope of jurisdiction of the intelligence community? And if it is, then we suggest they get a lawyer. We suggest they talk to the Inspector General, which is what happened here. The whistleblower did exactly what they should, except for the president. That's unforgivable, because the whistleblower exposed the wrongdoing of the president. In the president's view, that makes him or her a traitor or a spy. And as the president tells us, there's a way we used to treat traitors and spies. You wonder why we don't want to call the whistleblower? Well, first of all, we know firsthand what the whistleblower wrote secondhand in that complaint. There's no need for that whistleblower anymore, except to further endanger that person's life. That, to me, does not seem a worthwhile object for anyone in this chamber, on the other side of this building, in the Oval Office, or anywhere else.
The question is, you refuse to answer the question on political bias. Are the House managers refusing to tell the Senate whether or not the so-called whistleblower had an actual conflict of interest? There are 7 billion people on planet Earth. Almost all had no involvement in Biden's quid pro quo. Are the House managers unwilling to say whether the so-called whistleblower was a fact witness who directly participated in and could face criminal or civil liability for Joe Biden's demanding Ukraine fire the prosecutor who was investigating Burisma? And why did you refuse to transmit to the Senate the Inspector General transcript?
With respect to the ICIG, the President and his allies have tried to shift focus to the Inspector General of the intelligence community, a highly respected veteran of the Justice Department, and his handling of the whistleblower complaint. There was an effort to insinuate wrongdoing on the part of the whistleblower, and there's been an effort to insinuate wrongdoing on behalf of the Inspector General. The briefings that we had with the ICIG related to the unusual and problematic handling of this particular whistleblower complaint within the executive branch, which diverged sharply from any prior whistleblower complaint by anyone within the intelligence community. The Intelligence Committee is continuing its ongoing oversight to determine why and how this complaint was initially concealed from the committee in violation of the law. ICIG Michael Atkinson continues to serve admirably and independently as he is supposed to do. Like the Senate Intelligence Committee, the House Intelligence Committee does not release the transcripts of its engagements with inspector generals on sensitive matters, because doing so risks undercutting an important mechanism for the committee to conduct oversight. The transcripts remain properly classified in conformity with IC requirements to protect sensitive information. The ICIG made every effort to protect the whistleblower's identity and briefed us with the expectation that it would not be made public, and we are trying to honor that expectation. With respect to allegations of bias on the part of the whistleblower, let me just refer you to the conclusion of the Inspector General, which is, after examining the whistleblower's background, any potential allegations of any bias, the whistleblower drew two conclusions. The whistleblower was credible, meaning that whatever issue, perceived or real, the Inspector General found that whistleblower credible. The Inspector General also found that the whistleblower's complaint was urgent and that it needed to be provided to Congress. The Inspector General further found that it was withheld from Congress in violation of the law, in violation of the statute, and for that, he is being attacked. Now, counsel for the President rely on an opinion of the Office of Legal Counsel as its justification for violating the Whistleblower Protection Act and not transmitting the complaint to Congress.
Thank you, Mr. Manager.
Mr. Chief Justice, members of the Senate, on page 5 of the Inspector General's report, it states, although the Inspector General's preliminary review identified some indicia of arguable political bias on the part of the complainant. Now, that's in the actual statement. He goes on to say, involving a rival political candidate, such evidence did not change his view about the credible nature of the concern or what appears to be credible. But to argue that it does not include an issue of political bias, the Inspector General himself says that that's, in fact, at least that they said that their preliminary reviews indicate some political bias. Now, there's been reports in the media that the individual may have worked for Joe Biden when he was vice president. He may have had some area under his watch involving Ukraine. But I also thought it was just interesting that Manager Schiff just talked about the importance of how they control the process as it relates to whistleblower reports because of the sensitive nature of those. Do we not think that the sensitive nature of information shared by the President's most senior advisors should not be subject to the same type of protections? Well, of course, it has to be. Thank you.
Thank you, counsel.
When the whistleblower originally made a complaint about this July 25th call, and that was reviewed by the Inspector General for the intelligence community, he framed that whistleblower's complaint and wrote a cover letter framing it in terms of those laws. And he said that there might be an issue here related to soliciting foreign contribution to campaign, a thing of value, foreign campaign interference. That was specifically reviewed by the Department of Justice. The Department of Justice concluded that there was no such violation here. So that is not something that is involved in this case. President Trump's, the interview with ABC that you cited, does not involve something that is a foreign campaign contribution, something that is addressed by the laws passed by Congress. He was referring to the possibility that information could come from a source. And I think he pointed out in that interview that he might contact the FBI, he might listen to something. But mere information is not something that would violate the campaign finance laws. And if there is credible information of wrongdoing by someone who is running for a public office, it's not campaign interference for credible information about wrongdoing to be brought to light, if it's credible information. So I think that the idea that any information that happens to come from overseas is necessarily campaign interference is a mistake. That's a non sequitur. Information that is credible, that potentially shows wrongdoing by someone who happens to be running for office, if it's credible information, is relevant information for the voters to know about, for people to be able to decide on who is the best candidate for an office.
Please summarize the House of Representatives' three-stage investigation and how the President was denied due process in each stage. combined with Manager Schiff's repeated leaks during the House's investigation, do these due process violations make this impeachment the fruit of the poisonous tree?
The short answer, as I think I've indicated a couple of the times that I've been up here, is yes. This entire proceeding here is now the fruit of the poisonous tree. The Speaker had announced the result. There were going to be articles of impeachment. The Judiciary Committee had decided they weren't going to hear from any fact witnesses. They had no plans for hearings. It was all a foregone conclusion because they had to get it done by Christmas. Chairman Schiff was in charge of all the fact-finding, and he had an interest, because of the interactions of his office with the whistleblower that we still don't know about, to shut down questioning about the motive, the bias, the reasons that the whistleblower, how this all came about. And it produced a record that cannot possibly be relied on here. We've said many times, the Supreme Court has made clear that cross-examination is the greatest legal engine ever invented for the discovery of truth, and they didn't permit the President the opportunity to cross-examine anyone. And that's an indication that the goal was not a search for the truth. It was a partisan charade intended to justify a preordained result and to get it done by Christmas. And it's not a record that can be relied on here. The Inspector General for the intelligence community wrote a cover letter on the whistleblower complaint, which he had actually exaggerated in the complaint, the idea that there was a demand for some assistance with the President's re-election campaign. That was forwarded to the Department of Justice. They examined it, and they announced back in September that there was no election law violation because they did not qualify as a thing of value.
General Horowitz testified before the Judiciary Committee. He said their DOJ had a, quote, low threshold, end quote, to investigate the Trump campaign. At the hearing, Senator Feinstein said, quote, your report concluded that the FBI had an adequate predicate reason to open the investigation on the Trump campaign ties to Russia. Could you define the predicate? Horowitz replied, quote, yeah, so the predicate here was the information that the FBI got at the end of July from the friendly foreign government, end quote. Why is the legal standard for investigating Trump so much lower than the standard for investigating Biden? And why was it okay to get the information from a, quote, friendly foreign government, end quote?
The Inspector General's report found that the investigation was properly predicated. That was the bottom line conclusion, that this was not a politically motivated investigation. The Inspector General also found, though, there were serious flaws with the FISA court process. There were serious flaws in how the FISA applications were written, in the information that was used, and prescribed a whole series of remedies, which the FBI director has now said should be implemented. But they found it was properly predicated. They found they did not have to ignore the evidence that had come to their attention, that the campaign for the president was having illicit contacts potentially, that it may be colluding or conspiring with a foreign power. Indeed, it would have been derelict for them to ignore it. But the argument, the implicit argument here is because there were problems, albeit serious problems, in the FISA court application involving a single person, that somehow we should ignore the president's conduct here. That somehow that justifies the president's embrace of the Russian propaganda, that somehow that justifies the president's distrust of the entire intelligence community, that somehow that justifies his ignoring what his own director of the FBI said, which his lawyers ignore today, which is there is no evidence that Ukraine interfered in the 2016 election. Because of a single FISA application against a single person and the flaws in it, you should ignore the evidence of the president's wrongdoing. Turn away from that. Let's not look at whether the president conditioned military aid and a White House meeting on help with an investigation. Let's look at flaws in how the FBI conducted a FISA application. The one does not follow from the other. The reality is that what you must judge here is, did the president commit the conduct he is charged with? Did the president withhold military aid and a coveted meeting to secure foreign interference in the election? And if he did, as we believe we have shown, does that warrant his removal from office? That is the issue before you, whether the FBI made one mistake or 5 mistakes with the FISA application.
Let me actually answer the question. The Inspector General said, in a response actually from Senator Graham, when James Comey said he was vindicated by the Inspector General's report, the Inspector General said, no one who touched this was vindicated. With regard to the FISA, you make so light, Manager Schiff, of what the FBI did. It wasn't a FISA warrant. There was an order unsealed just days ago saying that the process was so tainted by the Federal Bureau of Investigation, so tainted that not only was the NSD misled, but so was the FISA court. For those that don't know that are watching, the FISA court, you can't blame the court on this, by the way. You have to blame the Federal Bureau of Investigation for allowing this to happen. That is the court that issues warrants on people that are alleged to be spies. There's no lawyers in those proceedings. There is no cross-examination. The court itself in its order said we rely on the good faith of the officers presenting the affidavits. Are there 2 standards for investigations? That is an understatement. But to belittle what took place in the FISA proceedings, frankly, Manager Schiff, you know better than that.
This does give me an opportunity to speak a little more in a more fulsome way about a point I made earlier about the unique importance of whistleblowers in the intelligence community. Our area of intelligence is unique in this respect. If you're a whistleblower who wants to blow the whistle on a fraudulent contract in a transportation project, you can go public. If you're blowing the whistle on misconduct in the area of housing, you can go public. You can have a press conference and you can declare the wrongdoing that you have seen. If you're a whistleblower in the intelligence community, however, you cannot go public. You have no recourse to bring to the public's attention wrongdoing except one of really 2 vehicles. You can go to an intelligence committee or you can go to the Inspector General. And in this area where our hearings are in closed session, where you don't have outside stakeholders that can point out the flaws in what an agency is represented, if you're in the Transportation Committee and someone comes in and they say, this high-speed rail project is on time and under budget, you have outside validators and stakeholders that can say, that's just not true. In the intel world where our hearings are in closed session, there are not outside stakeholders that are listening that can hold those agencies to account. And so we are uniquely dependent when there's wrongdoing on 2 things, self-reporting by the agencies and the willingness of people of good faith to come forward and blow the whistle. And we do injury to that when we expose those whistleblowers to retaliation. I don't think any of us would have imagined a circumstance in which a president of the United States before now would have called a whistleblower a traitor or a spy, or suggested that people that blow the whistle on his wrongdoing are traitors and spies, and we should treat them as we used to treat traitors and spies. I don't think we could have imagined a circumstance where a president of the United States would have told a foreign leader that the U.S. ambassador, our anti-corruption champion in Ukraine, was going to go through some things. I don't think we could have imagined that happening before this presidency. And sometimes you just have to step back and realize just how striking and abhorrent this is and what a risk it is to civility, to decency, to our institutions. We've become inured to it through endless repetition of attacks on anyone who will stand up to this president. And of course, the risk is the very reason we have a whistleblower protection, the very reason why whistleblowers should enjoy a right of anonymity, is that in the absence of that, misconduct and wrongdoing will proliferate. If there's not a mechanism for people lawfully to expose wrongdoing, you can bet that wrongdoing is going to increase. And that's why there have been great champions like Senator Grassley of whistleblower protections, Senator Burr and Senator Warner and many others, because we all understand, at least we did heretofore, the vital importance and contribution that are made by American citizens who bring wrongdoing to our attention.
I just want to clarify, we don't think there's any need to start getting into more evidence or witnesses, but if one were to start going down that road, I think that that transcript could be relevant, because my understanding from public reports is that there were questions asked of the Inspector General about his interactions with the whistleblower. And there was some question in public reports about whether the whistleblower was entirely truthful with the Inspector General on forms that were filled out, and whether or not, certain representations were made about whether or not there had been any contact with Congress, and that then ties into the contact that the whistleblower apparently had with the staff of the committee, which we also don't know about. So if we were to go down the road, we don't think it's necessary. We think that these articles of impeachment should be rejected. But if one were to go down the road of any more evidence or witnesses, it would certainly be relevant to find out what the Inspector General of the intelligence community had to say about the whistleblower, along with the other issues that we've mentioned about whistleblower's bias, motivation, what were his connections with the whole situation of the Bidens, and apparently if he worked with Vice President Biden, he worked on Ukraine issues according to public reports. How does that all tie in? All of those things would become relevant in that event.
What was the date of the first contact between any member of the House Intelligence Committee staff and the whistleblower regarding the information that resulted in the complaint? How many times have House Intelligence Committee members or staff communicated in any form with the whistleblower since that first date of contact?
The answer is, we don't know. Nobody knows. We don't know when the first contact was. We don't know how many contacts there were. We don't know what the substance of the contact was. That all remains shrouded in some secrecy. And as I said a moment ago, we think that the way this case has been presented, this body should simply acquit. There's no need to get more evidence to probe into that. But if we were to go down the road of any evidence or witnesses, then those are certainly relevant questions and relevant things to know about, to understand what those contacts were, what the whistleblower's motivation was, what the connection between the whistleblower and any staffers, and how that played any role in the formulation of the complaint, that it all be relevant to understand how this whole process began.
But let me say about this proposed disclosure of the whistleblower's name, I think that kind of irresponsible and reprehensible action should be sanctioned by the Senate. If any of our members disclose the name of a whistleblower, I think there's strong bipartisan support for preserving confidentiality of whistleblowers. Both Senator Grassley and myself and others on both sides of the aisle have really made a career's work of using whistleblower information and protecting the identity of whistleblowers. And nothing could be more abhorrent to an investigation of wrongdoing at the highest levels than disclosing a whistleblower's name. So I hope the Chief Justice will refuse to provide any question that gives any information about the identity of the whistleblower, and I hope the Senate will take immediate action against any senator who discloses it.
Senator Rand Paul is using a 1 o'clock question regarding the whistleblower. He says that the Chief Justice has not screened his question and it's coming. If he names the whistleblower, what penalty do you think is appropriate?
I think there are potential ethics rules, penalties in the Senate for this kind of irresponsible and reprehensible disclosure of whistleblower information, even if it's not their name. Disclosure of this information is abhorrent to the ethics and traditions and institution of the Senate, and I think should be subject to some kind of sanction.
The House managers proved The defendant's scheme involved withholding of military aid, withholding of a coveted White House meeting with the president of Ukraine in order to coerce, to extort, to blackmail that country into conducting or announcing these sham investigations, to helping him cheat in the election.
Using a 1 o'clock question he's going to ask regarding potentially the whistleblower involving their name. Do you have any thoughts on the appropriateness of that and what should be done perhaps by the Chief Justice?
Well, as I said yesterday, we protect whistleblowers. We need their cooperation, we need their support in making the country work. And I'm not talking specifically about this whistleblower, I'm talking about whistleblowers generally. We rely on people of good conscience to report misconduct. The only point in outing this whistleblower is to satisfy the desire of the president for retribution, and that is not something that this Senate should condone. It's meant to gratify the grievances of the president by talking about Christopher Steele or James Comey or Peter Strzok or Lisa Page. None of those people are responsible for the president's misconduct. Only Donald Trump is responsible for his misconduct, and he must be held to account. Thank you.
Has to be vintage Adam Schiff. I've never seen so many false statements, mischaracterizations made in such a short period of time.
Adam Schiff and his team engineered the entire process, the sham process we call it, because there's no better explanation. Secret hearings in the basement, the lack of the president's counsel being involved, having any opportunity of involvement for 71 out of the first 70 or 79 days of this whole proceeding. They didn't allow Republicans to ask questions. They didn't allow Republican witnesses. Look, this is all famously known now by all the American people. So the idea that they would be down here saying that this is illegitimate and somehow the president being acquitted today doesn't really count, that there'll be an asterisk next to this. The only asterisk in the history books will be about the sham single-party impeachment that this has been and that the Founding Fathers clearly warned us against.
There were 17 witnesses. 17 of those witnesses were called by Adam Schiff. 0 witnesses were called by the president's counsel. Not only was the president unable to call any witnesses at all, his counsel wasn't even allowed in the room for those 17 witnesses. It's over. It's time to acquit the president.
Regardless of what happened over here, House Democrats didn't do their job over there. On December 18th, we warned them. We stood on the floor of the House and said, there isn't enough evidence and testimony to impeach this president. But they were in a hurry to do that. And we told them, Senate Democrats aren't going to agree with you, and that's proven to be the case. 17 witnesses called over here, could have been 117. The number of witnesses available to the House Democrats was the exact number that the House Democrats wanted to call over in the House. They didn't do that.
17 to 0 is enough. Good news is the Senate is now not going to call any more witnesses. They don't want 18 to nothing. They don't want 19 to 0. They don't want 20 to 0. And we know that'd be the case. If another witness was called next week, then the Democrats would never stop. They'd want someone else because they want to keep going and go after this president. So Mr. Zeldin is exactly right. My colleagues are exactly right. It's time for this to end. It's time for the president to be acquitted, and we get moving with the American people's business.
In the state of Ukraine, there is no doubt whatsoever regarding the strategic partnership with the United States of America. That's why we are confident in the successful realization of all our common plans.
Question is, do you know any individual, do you personally know any individual who discussed the substance of the July 25th phone call or any matter associated with the call with any member of the press?
Thank you, Ranking Member, for clarifying. I do not.
Lieutenant Colonel Vindman, did you discuss the July 25th phone call with anyone outside the White House on July 25th or the 26th? And if so, with whom?
Yes, I did. My core function is to coordinate U.S. government policy, interagency policy, and I spoke to 2 individuals with regards to providing some sort of readout of the call.
Two individuals that were not in the White House.
Not in the White House, cleared U.S. government officials with appropriate need to know.
And what agencies were these officials with?
Department of State, Deputy Assistant Secretary George Kent, who is responsible for the portfolio Eastern Europe, including Ukraine, and an individual from the office of an individual in the intelligence community.
As you know, the intelligence community has 17 different agencies. What agency was this individual from?
If I could interject here, we don't want to use these proceedings.
It's our time,
I know,
Mr. Chair.
but we need to protect the whistleblower.
Please stop.
I want to make sure that there's no effort to out the whistleblower through the use of these proceedings. If the witness has a good faith belief that this may reveal the identity of the whistleblower, that is not the purpose that we are here for, and I want to advise the witness accordingly.
Mr. Vindman, you testified in your deposition that you did not know the whistleblower.
Ranking member, it's Lieutenant Colonel Vindman, please.
Lieutenant Colonel Vindman, you testified in the deposition that you did not know who the whistleblower was, or is.
I do not know who the whistleblower is. That is
So how is it possible for you to name these people and then out the whistleblower?
Per the advice of my counsel, I've been advised not to answer specific questions about members of the intelligence community.
Are you aware that this is the Intelligence Committee that's conducting an impeachment hearing?
Of course I am.
Wouldn't the appropriate place for you to come to testify would be the Intelligence Committee about someone within the intelligence community?
Ranking member, per the advice of my counsel and the instructions from the chairman, I've been advised not to provide any specifics on who I've spoken to inside the intelligence community. What I can offer is that these were properly cleared individuals, or was a properly cleared individual with a need to know.
Well, this is, I mean, you can plead the fifth, but you're here to answer questions, and you're here under subpoena. So you can either answer the question or you can plead the fifth.
Excuse me. On behalf of my client, we are following the rule of the committee, the rule of the chair with regard to this issue, and this does not call for an answer that is invoking the fifth or any theoretical issue like that. We're following the ruling of the chair.
Counselor, what ruling is that?
If I could interject, counsel is correct. Whistleblower has the right, statutory right to anonymity. These proceedings will not be used to out the whistleblower.
And I've advised my client accordingly, and he's going to follow the ruling of the chair. If there's an alternative or you want to work something out with the chair, that's up to you, Mr. Nunes.
Well, we've attempted to subpoena the whistleblower to sit for a deposition. The chair has tabled that motion and then has been unwilling to recognize those motions over the last few days of this impeachment inquisition process.
Thank the senators for the question, and I want to be very careful in how I answer it so as not to disclose or give an indication that may allow others to identify the identity of the whistleblower.